What's up, everybody? Welcome to the live. Welcome to the live. See everybody in the chat waiting. Brian, April, what's going on? Thanks for showing some support. Flowers, Terrell. Yes, everybody join me. I've got the TikTok crew. I've got the YouTube crew. What's up, guys? What's up, guys? We've got some news in the YSL case. Judge Whitaker has issued her final orders on the Max Shard's motion for fair trial, and then the final mistrial motion. And she is not declaring a mistrial. I think the word is out right now that there's going to be no mistrial. And we don't have court today, but we're there. Everybody knows that they're coming back Monday, and it's testimony. The jury is going to be back for the first time in forever. So since June, sometime in June, when Glanville called them off so they could start going through Woody's statements. They have not been back since then. So yes, as Dee said, give me a like here. We can we can juice the algorithm here and spread the word about Meghann the reporter and the report on the Young Thug YSL trial. But we've got a few orders to get through here that I'll bring up on the screen. TikTok crew, if you guys want to see everything, I'm going to have it up on the screen over on YouTube, so you can head over there. But the Bailey Barack show, thank you for the thumbs up. Thanks everybody for coming in. And yeah, as April Love says, what a week, huh? It's been quite a busy one for me too. I had a few things to do. I'm still getting some clips up too. If you guys go to my channel on YouTube and look for recent videos, I posted one this morning of them going through some social media posts of Antonio Sledge, who's coming up on the witness list. And this is possible impeachment material that prosecutors want to use. And one thing this emphasizes, and I commented on one of the TikTok videos, that right now the workload for prosecutors is crazy because they have so much to do right now. I mean, they must just be working 24/7 because, and it's stuff they should have done before trial. And it's kind of crazy that it wasn't done before trial. But I heard Judge Whitaker remark that all this stuff they're doing right now, going through statements that the YSL associates who are going to testify, statements that they made to police that the prosecutors might want to use as impeachment material, it really all should have been dealt with before trial in motions in limine. This is like trial preparation stuff that you do that Judge Glanville never required them to do. So right now she's required prosecutors, they have to give information in batches of 30 witnesses. The next 30 witnesses that are coming, they have to reveal all of the possible impeachment, or I forget what exactly her requirement is, but they've got to have all their material and evidence discovery ready to release to in batches of 30. And really it's stuff that any other trial or the trials I cover, they would have had that all beforehand, because like I said, like she said, this should have been done in motions in limine and not dealt with, during the trial while the jury's seated. So this stuff that they're doing with Antonio Sledge's statements, and I think it was Quindarius Zachary, little D, was the first one that they brought up. She's making them get this ready for all the other witnesses in 30 batches. So that's a crazy amount of work that the prosecutors have to do right now. So I remember I've talked before about, does it benefit? I always kind of wondered if the fact that Glanville was so disorganized and, he only got 2 hours of testimony in a day, doesn't it actually benefit the defense to have this testimony all scattered like that? But I guess not. It can be a benefit to streamline it if the prosecutor's case is so bad. And that seems like what we've seen when they actually get into the evidence, that it's really weak and they're really unprepared. So the idea that this preparation time crunch that they're in, it's certainly not unfair for the judge to require this of them, because like I said, this all should have been done before trial anyway. But it's unrealistic to think that it's not just gonna they're gonna be able to easily do that. It's certainly not unfair for her to require it, and saying that it's it's unrealistic is really not her problem, because it's their case. And they're the ones who decided to bring like a 65 count indictment with 191 overt acts. And they have 200 witnesses. I mean, what the hell? It's crazy that they're not prepared. So, yeah, I see miscellaneous say that Thugger Daly will straight up lie to his followers to give them false hope. And I don't think he's lying. And a lot of people misuse the word lie, because lie means that like he knows that this stuff isn't going to be passed, and he's just telling them that it's going to be passed, or that it has a chance anyway. And I definitely don't think that's it. I don't think he's lying. I just think that, you know, he sees the case differently, and he sees this stuff and thinks that it has a chance of being granted. And really it might have. Like, I mean, we don't really know what her threshold on this was. And she'd said earlier that she thought the call on whether Woody was coerced in testimony or not was a close call. And so, I mean, I think she might have come pretty close to granting. I mean, it just depends. I mean, the idea that she always had her mind made up is questionable, because, and like I said, I'd done a live a couple weeks ago a couple nights ago saying that I thought her tone had changed that day. And it did. I mean, it seems like if you went back that one day when Kayla Bumpus testified, the day of the evidentiary hearing, Kayla Bumpus and then Detective Long, it seemed like the judge was like kind of realizing how many problems this case had. But there's just so many things for her to weigh. And in the end, the indictment has so many serious charges in it, like the Chamel drinks charge, all that. She just had to kind of weigh this all. And coming into the case, I think she just wanted to like kind of try to wipe the slate clean, in that when she goes ahead of moving forward, if they screw up at all, it's going to be hard on them. You know, I mean, and the chances that Love and her team is going to be able to, first of all, just get all this work done. It's so much stuff to go through, like the next 30 witnesses. And I forget what their deadline is for the every 30 witnesses, but it's a ton. It's just going to create all this more stress on the trial team, and maybe they'll crack. But yeah, I think Thugger Daly is great in that. I mean, that's frankly the motions that I'm about to bring up. Like, it's him and Joseph who post them all. Joseph from Atlanta Journal-Constitution. And it's definitely like fan bias, but I think you can easily tell. I mean, it's transparent fan bias, at least, you know, he's not like trying to act like he's not on one side, you know. And I don't know. I think it's overall like a great source of information, but and frankly, like, he is not the one driving all the misinformation. You know, I think he's pretty honest about, like, you know, this is my opinion, this kind of thing. It's all these like lawyers on YouTube who don't actually practice law, or are retired now when they're like 34 or something. And they're the ones, you know, hyping it up and screaming it and, you know, everything. And then of course it didn't help that, I mean, in the end, Judge Glanville was recused. So that is like pretty unusual and scandalous. So that kind of raises hope that, oh God, this whole case is going to fall apart. But you got to kind of look at the reasons he was recused. It's like he was recused for publicly defending himself against the recusal motions, you know? So I don't know, but I think, I think the more voices in this, the better. Like, I've always kind of heard that if like you don't like what somebody is saying, or you don't like their contributions to the discussion, like, you don't try to quiet them or turn people away from them. Like, the answer to speech you don't like is more speech. You know, you can respond in your own way, but it just kind of depends on like who you're having a dialogue with and everything. But again, the news today is no mistrial. We're moving forward on Monday with Woody on the stand, and we don't know what exactly he's going to do, because remember, the big change is the judge thinks that Woody was told wrong when he was told that he could stay in jail through not just the duration of this trial, but the duration of everyone else's trial, which, gosh, that could be like 10 years. She thinks it's just the duration of this trial. And she told Woody that it would could be February or March of next year. So she's definitely planning on streamlining this and being more efficient, but that's still a really long time. But she did make it clear to Woody that he's under subpoena. He has an immunity order, so he can't plead the fifth. It's the same situation it was with Glanville. It's just before a much more competent judge. So, but it's the same thing where if Woody invokes the fifth or just says, I'm not going to testify on Monday, he's going to go to jail. But he knows, and he's been told that it's for the duration of this trial, not the next trial. It could be, 5-6 months or whatever, however long that is, 7 months. So I think when they ask him, the judge asked him straight up, if we ask you if you're going to testify on Monday, what are you going to say? And he said, depends on how I wake up. So I think it's 8:45, the jury's in. And I thought, I got to go back and check, but I thought I heard her say something about 8 a.m. for the attorneys to argue about something or something. So, which is like 5 a.m. in Los Angeles, gosh. But somebody said, I haven't been able to catch all of Woody's lives, but somebody says Woody said on a live a couple days ago that he's going to have fun this weekend because he might be in jail next week. And yeah, I mean, like I said, I wouldn't want to go to jail instead of like testifying, but I'm not in this situation at all. So maybe Woody is weighing the, consequences and seeing what he really has to lose here by trying to kind of save himself from being a snitch, because that's the label that he has right now, because he did all these police interviews and stuff. It's like years ago, how can he kind of make up for it? But whatever he does, he's definitely going to be on the stand Monday morning, because they have to put him on the stand to ask him this, like, are you going to testify? What's going on? I'm not really sure. Some judges I know would make sure that was done outside of the jury. They would put him on the stand in the morning before the jury comes in and see if he was going to invoke the fifth or not. And then if he does, or whatever, it's just boom, you're jailed for contempt. And so none of that would happen in front of the jury. But I'm not sure if she'll call the jury in first. But one thing is just for sure, this judge is definitely much more competent and like efficient than Judge Glanville. Things are going to be going much better here. But let's bring up her ruling on one thing. It was her order on Shannon Stillwell's renewed motion for mistrial. And this is when she ordered the prosecutors into evidence training on Brady versus Maryland, which is about exculpatory evidence, which I know a lot of people are saying, I mean, it's a slap on the wrist, and it is. It's ordered into training. We should be more specific and say that they were ordered to sit down and watch a video. And does it say how long the video is? We'll bring it up. But I mean, that's not exactly, intensive 2-week training somewhere, but it says that they've got to watch this video under the supervision of the judge. So I'm hoping that the defense moves for this to be done in open court. So maybe we can all watch them do it on YouTube. But and I know everyone says it's a slap on the wrist and it's disappointed, and it is, but it's also like ultra embarrassing to have this kind of order issued against prosecutors in any case and have it be such a high profile case. And it just kind of sets the stage for the prosecutors are in for a really tough time moving forward if they don't get their shit together. And it's just going to get worse for them. And like I said, it's certainly not unfair, the requirements that she's placed on them for witnesses, but it's a little daunting to think of what they have to be doing right now to get all that together. It's like, well, you guys better cancel your plans for the next 8 weekends, if you even had them. I mean, for the rest of the trial, they need to get their shit together, and it's just going to add to the stress of the trial for them. And I don't know, I'm predicting they don't handle it well, but we'll see. Let me bring it up here. Order on Shannon Stillwell's motion to recuse. Yeah, let me put it on the screen. Thanks for tuning in, guys. I wanted to give a shout out to some of my subscribers too. I'm still getting that set up here on YouTube, but I've noticed that I have three people have tuned in, gotten me subscribed here. So, or gotten subscribed to the channel. I'm going to try to get everything built up here and, get some special shows for the subscribers, but I don't know if any subscribers are tuned in right now, but I'll give them a shout out when I can. Alec, thanks for the super chat. You say, if he pleads the fifth, the state better have another witness ready. The judge will be upset if they don't. Yeah, for sure. She's made that clear that they have to have their witnesses ready to go. I've heard judges say that if there's a break like that, like if they don't have witnesses ready to go, he's just going to consider the case rested. She hasn't said that here, and that would be pretty extreme in the case when they have so many more witnesses to go. But yeah, I think they will. I mean, they better. They have to be nervous about whether he's going to testify. And if he doesn't testify, their case is pretty screwed. I mean, their case is kind of screwed anyway, because the idea that all these YSL members aren't going to kind of get up there and do the same thing, you know, you just wonder. But so much of their case rides on Woody, and they really need the jury to see all these past statements from him from 2015. So if the jury doesn't see any of them because he doesn't testify, I mean, there's going to be really no way for them to ever bring that stuff in. So, but one thing I'm wondering, I think Antonio Sledge is the next one. He took a plea deal too, because remember, Woody is not there under a plea deal. So we had Trontavious Stephen testify under the plea deal. Walter Murphy testified under the plea deal, and then Antonio Sledge, like Montauk, I think he's the next witness. I don't know if he's immediately next, but he's coming up, because remember at the end of yesterday, Max Shard, I've got this on the YouTube channel, Shannon Stillwell lawyer Max Shard raised a concern that he said he's heard that I guess it was Adriane Love met at a coffee shop with Montauk recently. And so he's wondering if there's possible Brady material that came out in this discussion. And she said she didn't take notes or record it at all, which is like, oh, that's convenient. And when you listen to the clip too, she basically all but admits she did that because she knew that if she took notes, she'd have to release them. But it was her and somebody else from the DA's office. So, I mean, you just wonder how cordial that was. And, you know, I don't know. It'll just be interesting to see what Antonio Sledge does if he's like that. Oh, right. Yeah. NA's right. It's Quindarius Zachary, because Quindarius Zachary was the first set of statements they went through. And that was Lil D. So that's why they went through all of his statements, because he was the most immediate witness. And then Judge Whitaker was like, okay, who are your other witnesses coming up that might have possible impeachment material that we need to sort through possible objections through. And it was, that's when Antonio Sledge came in. So yeah, thanks, NA. I think it's Quindarius Zachary. If another YSL member testifies right after Woody, it's going to be Quindarius Zachary, little D. He says, if you have to have Brady training, how can they prosecute this case? Yeah, it's pretty embarrassing. And it's just watching a video too. And the way she describes the video, she gets into what the video actually is. I wonder if there's a way to like Google it and bring it up here. But let me see if I can bring up the order a little bit better. It says, order on defendant Stillwell's renewed motion for fair and constitutional trial. Claim 1 is a plague of discovery violations, missing police reports, and Brady violations. And remember, Brady is actually a murder defendant from the 50s, John Brady, and his case led to the U.S. Supreme Court ruling, Brady versus Maryland, that requires the defense to turn over potential exculpatory evidence. So he's kind of one of the more famous names in American criminal law. But a Brady violation is when they don't turn that over, potential exculpatory evidence. So in her response to this is Judge Whitaker. She says, discovery is being addressed. This court has ordered the state to timely produce all discovery and undertake a concerted effort to secure and provide all police reports, including asking current APD personnel with specificity to search for and produce reports on the case. As recently as the court proceedings of Friday, August 1st, 2024, the court confirmed the state's understanding that Brady obligations include the disclosure of material impeachment items and reminded the state of its continuing obligations under Brady. It's pretty embarrassing that she has to do that. The state represented to the court that it has fulfilled all its Brady obligations. The court will address remedial Brady action later in this order. Claim 2. Prosecutorial failure to follow court orders, making of specious allegations against defense counsel and counsel for a witness, and lack of candor to the court. her response is, any past failure of the prosecutors to follow orders of the court is a matter of record. Aside from the broad assertion of denial of defendants' rights to due process in a fair trial, no specifics establishing this assertion and no claim of resulting legal error is alleged. Any potential error stemming from the prosecutorial failure to follow court orders may be addressed on motion for new trial and or direct appeal, assuming any conviction. Any specious allegations involving defense counsel, counsel for a witness, or lack of candor with the court is, at minimum, extremely unfortunate. Oh, and there's a footnote. And that's when you learn reading court documents, is you always have to read the footnotes. Sometimes they're not that good, but sometimes they're great. And she says, this is the footnote. She says, the court reminds all counsel that every Georgia attorney is bound by our rules of professional conduct and owes a duty of candor to the court. These ethical and professional obligations should be scrupulously honored, and prosecutors, above all, should endeavor to comport themselves so as to be above reproach on such matters. Exactly. The court understands that it has the authority to sanction counsel for violations of the rules of professional conduct that occur during an impact on a case before this court. The court declines that invitation at present. However, any future persistent failure to abide by the rules of professional conduct or lack of candor with the court may trigger the extreme sanction of removal from this case. The state's June 7th, 2024 motion for immunity, that's the next footnote. Let's go back up into the order and get to what leads to that. Okay, so she says, continuing on in the order, these items do not, however, establish a denial of defendant's rights to due process or a fair trial. And then that's footnote 2. She says, the state's June 7th, 2024 motion for immunity in compelled testimony of Copeland states, on Thursday, June 6, 2024, after an encounter with defense team members and members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of Fulton County District Attorney that Copeland might attempt to plead the fifth in order to avoid testifying against members of YSL. And then Judge Whitaker writes, even assuming that this is a willful misrepresentation as opposed to inartful drafting or a misunderstanding, the gravamen of the representation is that Copeland had indicated he might plead the fifth to avoid testifying in this trial. The sequence of alleged events is not the material aspect of the motion. So she goes on to say, and the court at present declines to impose the extreme sanction of removal of any offending prosecutors. But they're on thin ice moving forward with her. And I think a lot of this is driven by the fact that she knows Glanville was a terrible trial judge on this. And he just let this all happen and get away. But she thinks that now that she's set parameters and moving forward, I mean, yeah, you guys see the order here. But Claim 3 was improper evidentiary rulings by the predecessor judge. She's quoting case law here. She says, a defendant is entitled to a fair trial, but not a perfect one, for there are no perfect trials. It's a case from 2014 in Georgia. And it continues, evidentiary error, which involves mistakes under Georgia's procedural rules and evidence law rather than any constitutional violation, she finishes it, can be addressed in post-trial review. I know that annoys so many people there to just have her be like, oh, just address it on appeal. You know, that's what she's doing. But the next claim is mistreatment of defendants and their counsel by the predecessor judge. And she answers, aside from a blanket assertion, the motion does not detail any alleged mistreatment of defendants. Oops. might want to have some facts backing that up or some anecdotes backing that up. But she says the alleged mistreatment of defense counsel detailed in, she cites it, the lines in the motion, is not alleged to have occurred in front of the jury, and even accepted at face value would not rise to the level of violation of defendant's due process or fair trial rights. And I think one of these in the motion is, it's from back in August before they seated the jury, or back maybe September, but Max Shard says that he was threatened with contempt of court and jailing by Glanville in a private chambers meeting because Glanville thought that he said bullshit or something on the record in response to one of his rulings. And I can just imagine Glanville just flying off the handle like that. And I mean, Max Shard just says it wasn't true. And he says that, of course, if that happened, it was in the courtroom, it would be caught on video. And it wasn't on stream that day, live stream from TV, but they've got surveillance video that I think at the courthouse that would have caught it. So Max Shard was basically saying, I didn't do that. Where's the video of this? And he says he just never heard from them again. So it's kind of scandalous, to hear about that. It's like, oh, but it's also just like, this was so long ago and he's not on the case. And like she says, it didn't happen in front of the jury, and it would not rise to the level of violation of defendants' due process rights or fair trial rights. She says, as to remedies, the predecessor judge has been recused and the contempt issue outlined is moot. And she's talking about the contempt issue that Max Shard was threatened with. And remember, Brian Steele still technically has that contempt order against him from Judge Glanville, but he's appealing that to in Georgia, and I think he's pretty guaranteed to get it overturned. But the next claim was improprieties and illegality of the June 7th, 2024 ex parte conference. She says, in open court on June 7th, 2024, the prosecution requested an ex parte conference with the court. She cites the transcript. The defense was therefore on notice of this request. The defense also knew that the request was not to secure immunity for Copeland, as the immunity order had been signed in open court earlier in the same day's proceedings. Even assuming a right to be present for this June 7th, 2024 conference, no one on the defense team objected to the request or sought more information about it, thereby waiving any right to be present for that conference. And remember, this is the clip from a few days ago. She said this a few days ago, pointed out that they should have seen this coming. We can play that later, but she's citing case law here for the proposition that the defendant waived right to be present by failing to object after being informed of trial judges meeting with the jury outside presence of defendant and counsel. That's another case where that happened. That hasn't happened in this case. But she says, as for the topic of this ex parte conference, defendant assigns nefarious attempt to prosecutor Love's and Hylton's representations about their interaction with Copeland's main counsel, Jonathan Melnick. The court at this point declines the invitation to so view their representations, but refers the prosecutors to its footnote herein. Defendant complains that comments by the predecessor judge during this conference reveal his partiality to the state. Pretermitting the questionable accuracy of such characterizations, the issue has been mooted by the recusal of the judge from that case. So she had a couple of footnotes here. So she has a footnote after the line, defendant assigns nefarious attempt to prosecutors in Melnick. She says, she notes that Melnick supplemented the record with a statement in his place to his representation of Copeland and addressed the asserted conflict of interest. So this was during the evidentiary hearing the other day that I have some clips on. We've got Melnick's speech up online, discussion up online if you guys want to look at it. But claim 6 was the illegality of the June 10th ex parte. And remember, this is the big ex parte that originally sparked all of this, the one that they had actually with Woody. The June 7th one that they just recently learned of, like she said, they were noticed of the June 7th one, but they just recently got the transcript for it. That Woody did not attend that one. But the June 10th one is the one that Steele learned about a couple hours later and confronted the judge in open court and ended up getting the whole contempt of court proceeding going. It was crazy. But this is Judge Whitaker's analysis of that. Remember, there's been so much talk about that. But here she says, on June 10th, 2024, at the behest of Prosecutor Love, the predecessor judge the predecessor judge held an on-the-record in-chambers meeting with Love and stand-in counsel for Copeland, Caleb Bumpus. Following a recess at which time Love departed the meeting, Copeland and Prosecutor Hylton joined the meeting. Defendant's motion raises several challenges to this ex parte meeting. Did defendant have a right to be present? Did the ex parte meeting amount to coercion of Copeland's testimony? And did any Brady violations occur? She says the defense also, this is a footnote, the defense also raises the specter of another ex parte conversation between the prosecution and the predecessor judge. She says, or that a portion of the June 10th ex parte meeting was not transcribed because the predecessor judge seemed to know that the prosecution had a list of questions for Copeland, despite there being no prior mention of such a witness during the ex parte meeting. This knowledge is easily accounted for. The prosecutors had specifically referenced such a list of questions reviewed by Ms. Hylton with Copeland on the record during the prior Friday's proceedings. Thus, the innocuous source of the predecessor's judge's knowledge. There, yeah. I mean, that I've seen the YouTube thumbnails for YSL lawyers expose third ex parte. It's like, no, that was the judge's response to that. There's no there. That's how they found out there was a list of questions for Copeland. They talked about it in open court. But this is her assessment. This is when we really get into the meat of it, because this is the June 10th big one. She asked, did the defendants have a right to be present? And of course, she's just dealing with one defendant because this is Shannon Stillwell's motion. But under the Harvey rule, as it's known in this trial, they all are joined in on this, I think, unless somebody intentionally voiced out. But she says, defendant is correct. This meeting was about more than just the parameters of Copeland's immunity and whether he understood its potential ramifications. The initial stage of the meeting, before the first break, centered on the prosecution's concern with whether Copeland's main counsel was laboring under a conflict of interest. There's a footnote there. And it says, this court sympathizes with Mr. Melnick's understandable indignation at having his professionalism and his loyalties to his client questioned. The court likewise appreciates defense counsel's umbrage. I might be mispronouncing that, but I like this judge's order. She's all, and this is just refreshing as somebody who watched this whole trial and has seen so many trials. And I know, like Kathy Roussan from Law and Crime Network has seen a ton of trials too, and she thought the same thing about Glanville. She was just like, "What is with this judge?" And having never seen a trial in Fulton County Superior Court other than this one, you're just like, "Okay, so are all the judges like this? This is crazy." But so seeing this order and just hearing this judge is refreshing, and that I think they actually have like a real judge moving forward now. But again, they're not getting the orders that they want, but this is setting it up for a really tough time for prosecutors moving forward. But anyway, she continues in the order, and with the logistics of handling Copeland's testimony with stand-in counsel. But because these topics were all ancillary to Copeland's immunity grant, the topic of the meeting remained at its core, and as asserted by the prosecution, Copeland's immunity grant. Because the meeting dealt with Copeland's immunity grant and its ancillary issues, it was not a critical stage of state at the trial of which the defendant had a right to be present. And this is interesting because remember when I was looking at this and talking about it, I mean, you just kind of say, well, yeah, it was in the middle of the trial and he's a big witness and it matters, right? But this is when you read into the case law and actually see like what it was. And it goes back to what the prosecutors were saying, and that the defendants don't have a right to be there because this immunity grant is a prosecution issue that doesn't concern them, that they will know that he has immunity. And well, I mean, I can't get into their whole argument just off the top of my head, but it's interesting that she says it wasn't at a critical proceeding because it's like, well, it was in the middle of trial and he was a main witness. Right. But let's see why she gets into that. She cites a case from 1934. Wow. And it says a criminal defendant has a right to be present when his presence, quote, has relation reasonably substantial to the fullness of his opportunity to defend himself against a charge, but not when, quote, his presence would be useless as to or its benefit, but a shadow. And this is a federal case from 1985. The presence of a defendant is a condition of due process to the extent that a fair and just hearing would be thwarted by his absence, and to that extent only. And I know so many people would read that, like who are hearing this and just think that, well, doesn't that apply here? But here's Judge Whitaker's analysis of why she doesn't think it applies here. She says, defendant is correct that there are differences between the meeting in this case and the meeting in King versus State. And this is the controlling case in Georgia from 2000 that I guess prosecutors cited a lot. But it says, for instance, the meeting in King was to secure immunity for a key prosecution witness, and the defense was aware that the immunity hearing was occurring. Here, the defense was not given notice of the meeting, and immunity had already been granted to a key prosecution witness. So the topic was not whether immunity was in the public interest. Instead, its topics were the adequacy of the witness's legal representation and logistics about stand-in representation, as well as ensuring the witness correctly comprehended the meaning and impact of the immunity grant, what would and would not amount to contempt of the order granting immunity and compelling his testimony, and the potential consequences of failure to comply with the order. I want to make sure we get this footnote up here a bit. She says, this is a footnote on the preceding page. She says, the issue of Brady material being generated during this ex parte meeting but not produced will be addressed below. As to the allegation made orally on Friday, August 2nd, 2024, that Brady material was revealed to the prosecution in an off-the-record conference between Hylton, Bumpus, and Copeland during a break in the ex parte meeting, see the court's separate order thereon. We will. We'll go there soon. She says, but the state's reliance on King, let me make sure I didn't skip something here. Yeah. So she says, but the state's reliance on King does not demand that its facts be on all fours. The legal import of King for this claim is that because a defendant's rights are not the subject matter under consideration in proceedings surrounding a witness immunity grant, a defendant has no right to be present for discussions with the tribunal surrounding witness immunity. The fact that here, discussions included what testimony would subject the witness to a charge of perjury, what would subject him to punishment for contempt of the order compelling his testimony, and what that sanction might entail, even if incorrect, does not change the analysis. Defendant's rights were still not the subject matter under consideration. She cites a bunch of cases here, too. Two cases from 2018, 2009. She describes them briefly. We won't get into all that. She says, was the witness's testimony coerced? And this was big because, I mean, that this could, any of these findings, if she said yes, could tank the whole thing. And was Woody's testimony coerced during that meeting? Did they basically force him to testify? And she says, separate from any defense right to be present for ancillary proceedings concerning witness immunity, defendant has a right to a trial free of coerced testimony. She says, defendant asserts that certain arguably inaccurate representations made by the prosecutors and the predecessor judge to Copeland about the law of derivative use immunity, the applicable statute of limitations, which relates to crimes or crimes the defense does not specify, and the length of his possible incarceration for contempt coerced Copeland into testifying. I'm going to have to take a break here. I want to lose my voice here. Got to drink some water here. So she cites a couple cases. She says, here, Copeland had the benefit of counsel. Says, the predecessor judge did not, on the whole, use intimidating rhetoric, but rather sought to ensure that Copeland understood the nuances of the decision he had to make. And he explained that many of the decisions about what could happen to Copeland were not his to make, but were up to the prosecutors. Some of the information provided to Copeland may have been inaccurate. While it is likely that Copeland was not induced by any inadvertent or other inaccuracy to testify, the cleaner approach is simply to pretermit this issue, acknowledging past inaccuracies, and advise Copeland anew. This is the course that the council has proposed, and the parties have affirmed its efficacy. I'm going to bring that up here just because that did. And maybe she's going to tell him more tomorrow morning. But let's bring up that clip because I kind of need a break from talking. But let's bring up that clip of Woody in court 2 days ago. What was it? Wednesday.
All right. Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning from the bench and the stand to talk about the fact that the state is not interested in you pleading the fifth, and in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify, because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
Didn't understand anything. All right. So
No, I'm saying, like, I heard you, but I don't know what you're talking about.
okay. So tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you saying it's the same from last time?
Hang on a second. Yeah. The same one as last time. Yeah. This one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is, it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier. And I don't think that is
So I ain't got to wait till every defendant that's not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. Okay. So do you have any other questions? Okay. And do you want to talk to Mr. Melnick anymore about this particular issue?
No.
All right. So I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them we would essentially start over, because I want you to have a voluntary, to an extent, choice and knowing choice whether to take the stand and be questioned and cross-examined or not, knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they could charge you with perjury or false statements, but they can't, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say,
Well, can I speak?
You can,
I
yeah,
have
if you
told
have
the
a,
state
Huh?
I have told the state I have lied and lied and lied and lied.
I know. And
So how are they going to be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about. So
They said they're going to be able to charge me if I lie. Like when it's up to them to choose when I'm lying.
not prior. You've said you've lied and lied and lied in every. I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know. I mean, give me an example of something that you know he didn't do, and well, maybe not. Never mind. Don't do
Can I
that.
give you an example for what they told me?
Yeah, yes. And then I'll see whether that's what I think or not. Yes.
So she said that the only reason she won't lock me up, I just want to know if it still applies.
Okay.
She said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right. What was the first one?
Pleading the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth. Okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you could then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can say, I can admit to a crime on the stand, they can't charge me with it. They have said, you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. If you say, well, I committed some crime. Here's what I committed it with. I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So where they don't
formally
have
call it.
they facts together, like they saying something that they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime. For instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe and they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay? So what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come, and I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me. I'll tell you whatever I'm going to tell you. Or are you going to say, nope, I don't care if you throw me in jail. I'm not saying a word. I am not getting on the stand.
It depends on how I wake up.
Okay. All right. Well, then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning. You're free to go for now.
All right.
All right, Mr. Mel.
So that sets up what should be a pretty wild Monday. Needless to say, it's going to be an early one for me here in Los Angeles. And Los Angeles has a big trial going on right now in federal court to Tom Girardi, who some might know from Real Housewives of Beverly Hills, but he's and he and Erica Jane are still married too. They're technically filed for divorce, but their divorce has not been finalized. And he's a lawyer who was big in Los Angeles and he big everywhere. And he ripped all these clients off, and he's on trial for fraud. So I'm kind of splitting my time between that. But definitely on Monday, I've got to be front and center for Woody's testimony. But that whole speech that we just heard was the judge's way of dealing with the allegations that his testimony was coerced, which she's stepping away from that. But the problem with him getting bad information. So she dealt with that on Wednesday. Wednesday is when we saw him. Was that Wednesday when we saw him in court? But then this is her order that was just issued last night, where she says, while it is likely that Copeland was not induced by any inadvertent or other inaccuracy to testify, the cleaner approach is simply to pretermit the issue, acknowledging past inaccuracies, and advise Copeland anew. This is the course that the court has proposed, and the parties have affirmed have affirmed. And it says, it acknowledges in the footnote that this has already happened. It says, Copeland has since been recalled into open court on August 6, 2024, and in the presence of his counsel, Melnick, who also privately consulted with and advised Copeland, was provided clarifying and correct information on matters potentially impacting his choice whether or not to testify. All parties were present and consulted with the court prior to Copeland being re-advised. And then she moves into the next claim regarding the June 10th ex parte, and was there a Brady violation? Remember, that means was there exculpatory information given in that meeting that they didn't reveal? And it says, this has been a long running and multifaceted proceeding. Challenges have been myriad and formidable. Frustrations may have been mounting while fortitude was waning. And a needle in a haystack is not only sometimes difficult to find, but also easily overlooked. This court does not attribute bad faith to anyone on this issue. And yet, as soon as Copeland joins the June 10th, 2024 in-chambers ex parte proceeding, he states, "I have never been truthful a day in my life until I just made this statement right now." Copeland may have little credibility. He may speak in hyperbole, but the fact remains that for a defense attorney, this nugget by a key state's witness is gold. So when the prosecution not only did not reduce the statement to writing and produce it, but also asserted in court filings that the defense had no entitlement to know the contents of the ex parte proceedings, this amounted to suppression, whether willful or otherwise, of what was objectively Brady impeachment material. It's like, yeah, that was the problem when they did eventually get the transcript. So right now there isn't an ongoing Brady violation because they've got the transcript. They're going to be able to ask Woody about it. But it's pretty concerning that they argued against releasing the transcript from it. And, I mean, they're dumbasses. But she says, this is Judge Whitaker's order continuing. She says, the defense now knows of this statement and looked of all what occurred during the June 10th ex parte meeting. The contents of the meeting were ultimately revealed during the course of trial and in time for the defense to utilize it. So the failure to produce suppression of this information does not technically amount to a Brady violation. But the fact that a violation of a defendant's constitutional rights has been averted does not, under these circumstances, provide cause for celebration. What it does provide is cause for sober reflection and an examination of processes, procedures, and approaches that permitted this likely inadvertent but nonetheless serious Brady lapse to occur. Defendant seeks as a sanction the disqualification of the state's two lead prosecutors. Because this does not appear to the court to have been a purposeful violation, but rather a negligent overlooking of the impeachment value of Copeland's in-chambers statement, the court does not order their disqualification. At the same time, the court is cognizant that defendant's liberty, as well as the liberty of his co-defendants at this trial, is at stake, that the prosecutors involved are knowledgeable and experienced, and that this is not the first allegation of prosecutorial misconduct in this case. The court therefore orders, as a remedial measure, that the entire prosecution team working this trial submit to training on Brady and other professional obligations of a prosecutor. This training will consist of a video replay of training on this topic previously prevented by the Prosecuting Attorneys Council of Georgia. The court will provide the video, and the viewing will occur under the direction of the court. Like I said, God, that's so funny. It's going to be like going to after school detention or something. But like I said, I really hope that is somehow live streamed. I wouldn't like expect it to be, but it could be. But Mallory, thanks for your comment there. And I want to give you a shout out. I know you're one of my channel subscribers. I've got 3 channel subscribers, and I appreciate you all so much. I'm going to be doing more to build up my YouTube channel and really get the subscriptions and channel memberships going. So thank you there. But yeah, that was the 9-page order. This was her response to Max Shard, the lawyer for Shannon Stillwell. This is the response to the renewed motion for fair trial. And I remember when she first got on the case, there was a motion for fair trial pending, and she just like laughed at it. She's like, okay, well, in the intent that, I will make fair decisions and we'll hear the issues, your motion is granted. And she was just kind of laughing that they did that. And then obviously, as she's gotten to know the prosecutors a little bit better, she's kind of realized like maybe they had a legitimate reason for doing that. But, and again, I know everybody, and Doug Weinstein, who I'm, hoping we can get our schedules connected where he comes back here. But he had done stuff on, he had done a GIF on Twitter, doing a slap on the wrist or something on that, like showing that it was just a slap on the wrist, which yeah, it is. But I mean, it's like, what are the other possible punishments here? It's not like the remedy for a discovery violation. Like if they want to use evidence that they've released late and they release it too late to prosecutor or to the defense, she could exclude the evidence. But it's not like you can do that with Brady material. I mean, they have it now, and there's no. I mean, she's not going to exclude it. It's something that they want in. So what can she really do here? But other than recuse them, and I know that's what everybody wanted. But again, moving forward, it's going to be tough for them. Oh, somebody asked where the link for memberships is. That's a good question. But let me see here. If you just go to my channel, you should be able to see it. I think. Let me see. Membership. Let me check here. Let me see if this link works for you guys. I'm going to put it in the chat there. But we'll get into the next order. This is denying the motion for mistrial from Diamante Kendricks. So this is the motion for Doug Weinstein, and he had supplemented it. But she says, before the court is defendant Kendricks' July 23rd, 2024 motion for mistrial, supplemented on July 31st, 2024. The court has also considered the state's response, oral arguments by the parties, and the transcripts of the June 7th and June 10th ex parte and the applicable law. The motion for mistrial asserts 3 grounds for mistrial, with the supplement asserting a related 4th ground. 1, that it is impossible to redo the proceedings that occurred on June 12th, June 13th, June 14th, and June 17th before the jury in the interim between defendant's June 12th, 2024 motion to recuse the predecessor trial judge and his ultimate recusal. 2, that the defendant's constitutional right to be present at a critical stage of the proceeding was denied when neither he nor his counsel were present for the June 10th, 2024 in chambers on the record ex parte discussion amongst the court, prosecutors Love and Hylton, counsel for witness Copeland, and witness Copeland himself. 3, that the defendant's due process rights were violated when the predecessor trial judge allegedly aligned himself with the prosecution team by his comments during the June 7th, 2024 in court on the record ex parte discussion between the court and the prosecutors Love and Hylton, and allegedly coerced witness Copeland into testifying during the June 10th ex parte. And the 4th claim is, as raised in the defendant's supplement, is that bias of the predecessor judge constitutes due process violation of defendant's rights in the Constitution of the United States and the state of Georgia. And this is Judge Whitaker's response. She says, Kendrick also asserts that the motion for mistrial was goaded by the state when it requested that the predecessor judge hold the June 10th ex parte meeting, which has been the subject of much discussion in this case, absent Kendrick from that meeting and joined with the predecessor judge in the coercion of witness Kenneth Copeland. We kind of know how this is going because we read the previous order of case. So a lot of her logic here is going to be the same. But she says, Defendant Kendrick raises issues that the court has already addressed in granting Defendant Williams' motion to invalidate and strike all proceedings that occurred in the above referenced case. And that's Woody's testimony. As noted, the court has been working with the parties on which testimony and evidence should be resubmitted / re-presented to the jury in this case, and whether any other evidence at issue will be stipulated to, as well as any needed rulings and or instructions related to the same. There's a footnote there. She says the order granting Defendant Williams' motion noted that the court would work with the parties, and since that time, the court has done just that, formulating instructions and addressing evidentiary issues with the input of all parties. We can agree. This judge is just like such a 180 from Judge Glanville. It's crazy. But she says, as much as the court does not find that there is an impossibility to addressing these issues, and therefore there is not a basis to grant as such, the court does not find that there is an impossibility to addressing these issues, and therefore there is not a basis to grant Defendant Kendrick's motion for mistrial on these grounds. She says on June 10th, 2024, she thinks it's an error that the motion mentions a June 12th meeting. She just thinks it's a typo. They meant June 10th. But she says on June 10th, at the behest of Prosecutor Love, the predecessor judge held an on-the-record in-chambers meeting with Love and stand-in counsel for Copeland, Kayla Bumpus. Following a recess at which time Love departed the meeting, Copeland and Prosecutor Hylton joined the meeting. Defendant's motion raises several challenges to his ex parte meeting. Did defendant have a right to be present, and did the ex parte meeting amount to coercion of Copeland's testimony? And did the predecessor judge's comments and participation in the ex parte meeting rise to the level of due process violations? And the claim was that the ex parte meeting was at a critical stage and violated Kendrick's rights. And she's already addressed this in the other order, but she says a critical stage, she defines it with case law here, but she says defendant is correct that this meeting was about more than just the parameters of Copeland's immunity and whether he understands its potential ramifications. Okay, this is like a copy and paste from the other one. From the other ruling that we just read, so I'm not gonna get all into it then. But yeah, okay, yeah, that's what she did. Here's something original to this. She says the claim was bias on the part of the predecessor judge constitutes due process violations. She says based on the comments in the ex parte transcript made by the predecessor judge about counsel, both for the defendant and for witness Copeland, as well as about outside agitators, defendant asserts that the predecessor judge during this conference revealed his partiality to the state. She says pretermitting the questionable accuracy of such characterization in our discussions, this issue has been mooted by the recusal of the judge from this case, and that's familiar. I realized that was in the other order too. So nothing really new there. That's just her reiterating what she had before. But the final one, she ruled on alleged ex parte Brady violations. And remember, that would be exculpatory evidence violations that they didn't, exculpatory evidence that they should have released, but didn't. Read through this here. She said the court finds that an off-the-record conversation did occur at the behest of Hylton with the consent of Bumpus. And this is what I thought was not good, when I heard this. But I think the point is going to be at the consent of Bumpus. But because, Brian Steele was alleging that there was an off-the-record discussion and that there was discussion about Donovan Thomas's murder and that there was like a confession. And Bumpus testified to that, but her testimony really was not, you could tell that the judge was not buying her testimony. She didn't buy Kayla Bumpus's testimony, but then when investigator Long from the district attorney's office testified, he confirmed that there was an off the record discussion here. So I was kind of thinking that was a problem, that if anything would be a problem here, it would be it would be that. So here's the judge addressing it. She says, Glanville was not present for the conversation. It says, during the conversation, Hylton advised that if Copeland took the stand and either pled the fifth, having been told that such a plea was no longer viable due to the grant of immunity, or claimed that he killed Thomas, as Hylton maintained that the prosecution knew this to be demonstrably untrue, the prosecution would charge him with perjury. Also during the conversation, Copeland made the statement, "You don't know what I did or didn't do." She says, during her testimony, Bumpus claimed that Copeland also said that he knew more about the Infinity in someone not currently on trial. But Bumpus also testified that Copeland's comment, "You don't know what I did or didn't do," was the extent of his comments regarding the killing of Thomas. Bumpus claimed distinct recollections of certain portions of the June 10th, 2024 events and acknowledged lesser recollection of other details. She also acknowledged that there were times during the in-chambers meeting when she met and conversed privately with Copeland. Finally, Bumpus testified that once she, Hylton, and Copeland completed their off-the-record conversations and were joined by the predecessor judge and his court reporter, Copeland consciously endeavored to ensure that she immediately placed on the record everything about the substance of the off-the-record conversation. Yet Bumpus never had the record reflect that Copeland had, allegedly, just revealed to Hylton that he had additional knowledge of the Infinity in related connection to someone not currently charged. It says Long was present in the ex parte meeting from the time Hylton and Copeland joined throughout the remainder of the meeting, including for the off-the-record conversation. And that's how they know it happened, because he was a credible witness, at least in the judge's eyes, and he testified to that. But Long testified that Copeland never said anything about an Infinity in Hylton's presence, and that he would have remembered such a comment because it would have been noteworthy. Whitaker continues, in addition to the testimony of Bumpus and Long, the court has considered Bumpus's knowledge as an attorney of her duties to her client and to the court, as well as the possibility that Bumpus, who admitted a lesser memory for certain portions of the ex parte meeting than others, may have confused her private conversations with Copeland and her conversations with Copeland that also included Hylton. Regardless, the court credits the testimony of Long that Copeland did not, in the presence of the prosecution, either state or intimate that he knew more about the Infinity and its connection to someone currently on trial. So no Brady material was revealed in the consensual off-the-record meeting among the prosecution, Copeland, and Copeland's counsel. Interesting, because because I was thinking, like, what about the we're going to we'll prosecute you for perjury if you admit to killing Donovan Thomas. But I can see them saying that it doesn't rise to level. That was already known and on the record that they would do that. So she says, as the court finds that there is no Brady violation with respect to the unreported portions of the June 10th, 2024 ex parte, there is no relief to be provided. Thus, no mistrial. There's no recusal. There's nothing like that. And that's the end of the order. So, so Jasmine, hey, thank you for saying hi. They're on YouTube. And then, Skip Flanagan says she is correct that one witness, one mistake doesn't equate mistrial. It's amazing how many people are hell-bent on not seeing people get justice for crimes, even murder, different world. And that's one thing to consider is when you read through that indictment, there's some serious freaking charges in there. And there's a ton of stuff that we haven't even heard evidence on, and especially the Chamel drinks, which it just amazes me that prosecutors put together this case. And it's like 8 months in, and we have not heard anything about a murder that occurred just 2 years ago. And we were hearing about like guys riding scooters through a mall like 8 years ago, and some Infinity crashing into the side of a laundromat. I mean, and they probably just thought that they'd kind of save maybe the best for last, because I don't know what kind of evidence they have about the Chamel drinks murder, but I've heard that there's surveillance video, and we just haven't heard anything about that. But when you consider the gravity of charges like that, I mean, the idea that anyone is going to dismiss an indictment like this and with prejudice, it would have to be I don't know. We'll see what happens moving forward, though, because like I said, the judge has really set the stage for much stricter standards and a much more efficient trial moving forward. And it's just crazy that the prosecutors were so unprepared, but the requirements that she has placed on them means that, I mean, they must be having to work 24/7 to get all this stuff done as they should. So we'll think. And yeah, I see Jasmine says, yeah, true, multiple murders, but you would think they would take it more serious. That's true with the prosecutors, the way they put together this case. And if supposedly, because remember, we have not even seen any evidence on Shamel Drinks. If supposedly they have such good evidence about this Shamel Drinks murder, it is really irresponsible of them not to have just charged that separately as its own murder and instead put that together into this huge political RICO case and run the risk that they're going to get an acquittal on that when, apparently it's just such great evidence. But like I said, we haven't even seen any evidence of the Shamel Drinks thing yet. We'll see what happens later. But yeah, so again, no mistrial, no prosecutors being recused. And I know there's definitely a debate about whether that training order for the prosecutors that they have to watch this video about Brady material and exculpatory evidence is really any kind of punishment. But that is really ultra embarrassing for not only them, but just the Fulton County District Attorney's Office, because there are so many eyeballs on this case right now. And so it's not good, but I can definitely see why people are saying, gosh, that's like hardly anything at all. But anyway, thanks so much for tuning in. I've got some more clips to post. I was just getting ready for one before I went live. That was I don't know if people were paying attention to them going over the calls and the possible impeachment material, but it's a jail call that I think it's Monk. I think it's Antonio Sledge jail call or one of them jail calls, but she listens to like 60 seconds of it and gives up. And it's like, y'all, it's too muffled. I can't understand it. I'll just listen to it in my chambers. But I was going to post that. And I think there's some more stuff to post. But again, the big day is Monday morning, and show me some love for being in Los Angeles and having to get up at, 4:45 in the morning to get my stream ready if I want to, which of course I could just, throw in the towel, but I have streamed it every day since the first day, and I'll be damned if I'm going to stop streaming it now. So if people want to get up with me and show me some love by watching my stream, I'll be stoked. But again, I love doing the clips and the highlights. So go to the recent videos. And then one thing I try to do that I think kind of sets my channel apart is the playlists. When you go to my YouTube channel, there are playlists for like the evidentiary hearing. And that's kind of a challenge for me, is learning how to organize everything into different things. Like right now I've got the channel list up for, it shows the past statements stuff that I want to get going here, but let me bring it up, because I know a lot of people don't. Somebody once told me, who does a lot of stuff on the internet, she's like, Megan, if you don't just put that directly right in front of their face, they are not going to see it. Like if it's over on a side, like she says, I have to pin it like directly in the middle. I have a little more faith in like internet viewers than that, but yeah, the past statements, impeachment, evidentiary hearing into June 10th. Whitaker, this one's a pretty broad topic for a playlist right now, but I'm going to try to do some more with that. Attorney interviews, here are all the lives. Donovan Thomas's murder. That one gets a lot of hits because I've done a pretty good collection of that. Woody's old testimony, cross exams, the barbershop trial witnesses. These guys were my favorite. You guys remember that day? It was like the one day it actually felt like maybe this was actually like a real trial that was going to become efficient under Glanville. They had a bunch of witnesses all in one day, but then Brian Steele arrested for contempt. And you can find a bunch more playlists on here too. I've got a playlist for Lil Wayne's bus shooting, YSL trial police testimony, Lakia Gaither, Dexter Montgomery, Adriane Bean, which I still need to catch up on some stuff from yesterday. Cause like I said, I've been in court over in LA federal court for the Girardi hearing. So I've kind of been watching stuff later on, but I heard people saying that they were hearing they might recall Adriane Bean or something. I don't know. I don't want to spread rumors, but if anybody can confirm for Adriane Bean, but D, yeah, we appreciate you. Thank you. And then yes, keep streaming, Roan. Yeah, I've been showing up every day. Appreciated, Peter. Thank you. And yeah, D, it really has. It's grown so much. I want to keep moving forward. We've got some big cases coming up in LA. ASAP Rocky is going to be on trial in November. So I live in Atlanta. Whoops, I didn't mean to highlight that. But it says, are you going to be streaming when the attorneys get there at 8? I'm going to plan on it. I mean, I hope so. That's really early, because if they're there at 8, to get up and get the stream ready, you got to get up at least, 4:50 a.m. But when I was living down in South County and taking the train up to Los Angeles for court, I would get up that early. So, and this is just, basically just rolling out of bed and going over to the computer and like turning it on. You don't even really have to do much. So yeah, I am planning to do that. So, oh, Jan, thank you. Yeah. Regarding Adriane Bean, they're going to call him back. Oh, so yeah, because he was such a great witness last time. No, ma'am. Yes, ma'am. But that'll be fun. Well, I think we're definitely in for a huge change in the trial, just in terms of, obviously, I mean, like I said, I don't think we could have had a more different judge here, but the orders are in. And again, I'm going to send out a story summing everything up, and it'll have a link to everything with, some videos, but a link to the orders if you guys want to check it out. So legalaffairsandtrials.com is where I've got everything at. So let me bring up, it's my Substack, but you guys can sign up for my mailing list and get everything in there. And I cover a bunch of different cases on there. And it reminds me, I should have lightened this photo of Tom Girardi, but this is Tom Girardi's trial there. I've got Tory Lane stuff, some NFL stuff, latest on ASAP Rocky, more Tom Girardi. I'm hoping to do a Tom Girardi article next week. But Karma, thank you so much. Meghann the Reporter. I got to get my merchandise set up on YouTube too. If you guys go to MeghannTheReporter.com, I've got William. Thank you so much for the love. And Jody, yes, thank you. And I should give an update on the Girardi case. The problem is, right now, I'm just kind of learning how to manage the audience, because kind of the fear is if I set a live on another topic that isn't Young Thug, I'm not going to get any viewers. And then if I just start talking about Girardi during a Young Thug live, people are going to be like, this isn't the same trial. But I need to do a multi-topic live, because one thing I want to do, and after I saw that order for the Brady training, I was like, God, this is so embarrassing. I texted it to a public defender that I know in Orange County, who's kind of famous for exposing all these Brady violations in the big snitch scandal in Orange County, and asked him if he would want to come on the channel sometime to talk about his experiences with Brady violations and all that. And he said yes, definitely. He said he's not really supposed to talk about other people's cases, which is going to give us some restrictions, because ideally he'd be able to talk about all his experiences in Orange County and then kind of weigh in on the Young Thug case and that stuff. But as it would be, is he'd only really be able to talk about his experiences, and then he can't talk about the other case. But we might be able to do that. So I would like to, but yeah, I'd like to do a Girardi thing, especially I want to get an article together, and then they're probably going to have a verdict by the end of the next week. Prosecutors were saying they're going to rest. They're not in court today, but they're back on Monday, which is going to be tough, because with Woody back in session, but it's not till 9 a.m., which is that's noon on East Coast time. So hopefully they're on a lunch. But my plan is to walk over to the federal courthouse, which is only 10 minutes away, at 8:30, and then I can kind of just watch the Young Thug trial in the hallway and keep an eye on the Girardi trial when it's going on. But that's funny. Vamp says he's a rare fan of both Real Housewives and Young Thug. Well, really, the Girardi trial is really good too. And when I was sitting in there, I was like, okay, I need to be in here for as much as I can. It's not as good as the Avenatti trial, the other thieving lawyer who went on trial a few years ago for wire fraud, but just all the evidence that's coming in and the testimony and who Girardi was in the legal community, I was like, oh, I've got to be in there for that. And it's, like I said, it's going to be over next week, but it's going to be stressful having that go on if Woody's testifying, or Quindarius Zachary or something. But Karma, you ask if I've thought about interviewing Thugger Daily. I totally should. It's a he, from what I know, from what I've read, the interviews he's done with other stuff. He wants to stay anonymous, and apparently it's partly because he doesn't want his work to know that he watches the trial and tweets about it all day during work. But I think he said there's other reasons too. But yeah, because I don't think he doesn't talk very much live, but he's done some Twitter spaces before where he talks. So yeah, no, I think it would be fun to get him on here. We'll see if we can. and this is hard for me to answer. Like, is he cooked or not? Like, I don't think so. Right now, I don't think so. Like, the way the case is, it's just like, if it went to the jury right now, I don't think they've proven like a racketeering conspiracy, but it's still, they have so much more to go. And like I said, it's going to be interesting to see whether streamlining the case like this and making the prosecutors more efficient, like, really makes the prosecutors more efficient, or if they just get so stressed out, it makes the trial like even worse for them or something. Cause it's hard for me to say. And you just don't know anything about the jury either. But, somebody asked if I think Kayla Bumpus did herself a disservice by starting a platform surrounding a case that she was part of. Yeah, I mean, I'm not really sure, but I know I've heard her talk that she's not really sure, how much more she wants to pursue like criminal defense work. So, she's just trying to, get on the internet like everybody else. I don't know. I kind of try. I just kind of see it as, she's not. She was involved in the case, but she's kind of irrelevant right now to the whole thing. So, moving forward, I don't think we're going to be hearing much about her in the case anymore. But it's going to be interesting. Again, like I said, the judge, her expectations could in no way be described as unreasonable. Like I said, it's just crazy that Glanville didn't have them be more prepared for this. And then also the idea that the prosecutors need a judge to tell them to be prepared. Like, it's crazy that they haven't prepared for these witnesses like this. But just the logistics of the orders that they're now under from this judge to have all their possible impeachment material ready for the next 30 witnesses so they can go through it all and decide what's in or not. Because it was refreshing to listen to her go through these statements, because she's basically telling them how she's going to rule on objections. She was saying, here's a statement. What would the possible defense objections for this to be? Somebody says relevance, and they debate for a few minutes about that. And then she says, okay, I would object to relevance thing on that. And it's like, wow, that's going to make the trial much better going forward. But she wants them to go to do that. She says prosecutors need to get that ready for the next 30 witnesses. I'm like, dude, that's so much freaking work. Hope you guys didn't have like dinner plans this weekend or something, but, yeah. Mallory says her reasoning is fair. Yeah, totally. In no way could those be described as like unreasonable expectations for her. It is just insane that Glanville didn't allow them to do that. Because I mean, Whitaker said all of this previous statement stuff should have been dealt with in motions in limine, like before trial, before jury selection, that kind of thing. And Glanville was just like, no, let's spend 10 months interviewing 2,000 people for jury selection. It's crazy. But anyway, thank you guys so much. I feel like I'm probably neglecting the TikTok chat. I've been answering all the questions in YouTube, but if you guys have questions in TikTok, I'm sorry if I missed them here. But again, thank you all for tuning into the channel. Yeah, Mallory says this is all Glanville's fault. True. And prosecutors too, but like, if Glanville had showed a little bit of leadership on this, he could have gotten them into shape, or demanded they be in shape better. Yeah, she says, I blame the state, but it was his court. Yeah, totally. It's that whole leadership thing, the shit starts at the top and trickles down kind of thing. But anyway, thank you. Mallory, I know you're a member for the channel. So again, if you guys head to my channel and you can see I'm trying to build the membership up. And one thing I need to do is attach my my store to it. You can go to MeghannTheReporter.com and see my googly-eyed bitch and Meghann the Reporter merchandise. So I've still got some mugs left. I'm kind of getting to the point where I need to decide whether I want to like actually order more and really go all in. But like I said, I need to promote it better. Anytime I promote it, I sell some stuff. But anyway, thank you guys so much for tuning in. I will see you all on Monday. It's going to be a big morning, a big day. And I will, I've got some more YouTube clips to post. I'm not sure if I'm going to be doing a lot of TikTok clips this weekend because I want to save up for Woody, but I do have some more YouTube stuff to share. So check it out. Thank you guys so much. See y'all later. See you later, Mallory. See ya.